Welcome to CMMC Unacknowledged, where we answer the unanswered questions that were asked during the monthly CMMC-AB Townhall meetings. My name is Todd Stanton. I'm the Regional Sales Manager for all things CMMC at Etactics. And as always, I'm joined by Ty Wittenberg. Ty is the Senior Information Assurance Manager at Rain Associates. Welcome, Ty.
Hey, Todd, thanks for having me again. As always, great opportunity to chat with you about seems to be our favorite topic, CMMC.
And today we're going to focus on CUI. So our question for this episode is, does the CUI FAR Rule, which is currently in review at the Office of Information and Regulatory Affairs, OIRA, does that need to be updated prior to CMMC rulemaking?
So, great question. And I don't believe that it necessarily needs to be. Well, let me back that up. When you look at the National Archives around CUI, there's basic CUI and then there's specified, right? So that I think the language in it clearly needs to be defined because I think that's going to have an impact on the bifurcated status on level twos on whether you need to have you can still continue to self-attest, or if you will have to have a C3PAO and a DIBCAC assessment. So to answer your question, it's a little bit murky. So I'm not an expert in rulemaking per se, but I will say to you that there's a lot of moving parts going on based off of what we talked about in the town hall. I think there'll be some blushes at what that looks like in the rulemaking. But my opinion is that we've already got a framework around that CUI needs to be protected. And so, whatever that review happens at the Office of Information and Regulatory Affairs, the CMMC ruling is all encompassing.
And so, one of the reasons why I asked that question was in doing some research, it appeared that level 1 of CMMC, which is federal contracting information and protecting information systems that house non-CUI but federal contract information, that stemmed from a FAR case that was, I believe, published around June of 2016. And that really seemed to be kind of the basis for those 17 basic cybersecurity requirements that we see in level 1. So I just didn't know if there was, a connection between these FAR CUI case that's in progress in rulemaking, and then what's happening with the CUI rules for CMMC.
So let's roll that back a little bit, right? Because CMMC level 1, whether you're talking about the initial version 1.0 or now version 2.0, and there's some Delta training that's been put out for RPs and RPOs by the CMMC-AB. CMMC level 1 specific focus and the basic safeguards around 52204 are set up to be put controls in place around federal contract information. And while I guess you could lump it as CUI is different than the contract information itself. And so while it's not necessarily public information or information that we want as a nation to be shared with other nation states, it is not CUI. It requires protecting. It requires an information system and some basic level of controls and network segmentation to identify that. But it doesn't require, well, please don't take this the wrong way, audience or you, Todd. It doesn't require you to have as strong or as stringent information security systems and controls in place around your information system to protect it. So it needs to be protected. It's probably information that necessarily couldn't be found through any type of open source intelligence, but we don't want to give nation states the easiest capability to get to it. So level 1 is clearly about FCI, federal contract information. And then level 2 is when we really start getting into the nuts and bolts around controlled unclassified information, that's CUI, and even in some cases, CTI or CDI. Now, I don't want to go too deep in the weeds in that, but all in all, CDI, CTI all of that information rolls up and lumps into your controlled unclassified information.
Okay. And so another thing that I had researched was when the DFARS came out in 2016 that pointed to NIST 800-171, because this CUI FAR rule wasn't in place, it's almost like DoD came up with a new term called covered defense information, which included things like controlled technical information, as well as other categories of CUI. So when this FAR CUI rule happens, does it potentially impact the type of information that's covered under CMMC or referenced in NIST 800-171 and the DFAR 7012 clause?
I think it's going to have impact on your levels, right? So we've already discussed that level 1 is your federal contract information. That's where that CUI, whether it be CDI, CTI in there, and that bifurcated process that the CEO, Matt Travis of the CMMC-AB talked about, that bifurcation process in alignment with the DoD, I believe that's where some of that's going to come into place. And so you've got all of these moving parts with, the National Archives that sets the tone for the CUI, the rule decision-making process and the partnerships that you have to have with the Office of Information and Regulatory Affairs. I think the CMMC, once again, is wholly encompassing the ecosystem of it, the language. Once that language is clarified around, CDI or CTI in that rulemaking, clearly I think you'll have some better understanding as we as RPs or as assessors will come in and understand, how an organization will need to be assessed. It's my belief that CDI and CTI, depending, if it's based off of national security, will put you at a higher level of CMMC compliance that you need to be at. And so some of that clarity around that documentation and unmurkying the waters will be beneficial.
Okay, and then the last thing that I wanted to ask your opinion on, when it comes to marking CUI, I understand that the government may provide specifications as part of a contract, and those flow down from prime contractors, the subcontractors, and suppliers. But it's also possible for CUI to be created, downstream and maybe moved up. And so when CUI is created, right now the burden seems to fall on the contractor or the supplier to know that what they're creating is CUI, correct?
That is correct.
And so one of the analysis I was reading of the impact of when the FAR CUI rule comes into effect is it will move that burden back to the government so that the government would be responsible for telling the contractor, if you create X, Y, and Z as part of this contract, then that is considered CUI, which I feel like would answer a lot of questions that I hear from organizations in the defense industrial base today about the unmarked CUI that they're creating. Would you agree? Do you have any comment on that?
I would. I think our government and the branches, right, that we have, the executive, the judicial, all of that stuff, right, has impacts. And so with that, there's this disparity of information. You're talking about CMMC. I was with a client the other day that has FAR, DFARS, ITAR, like one of their clients who is a prime just kind of boilerplated all of that information on there because of the murkiness and uncertainty. Now, the particular item that he was helping them with is commercial off the shelf, so he shouldn't have to be burdened with that. But he asked me a question about there's a piece that he sends down to a subcontracting vendor that he strips all of that information and then just sends the specs to them, right? Part of that is because of a competitive advantage, I think, so that he doesn't lose that capability to maintain the relationship. And where I'm going with this is, even though he's sending it to them without the markings from the prime, he still needs to mark it as controlled unclassified information with those FARs, with the federal acquisition regulations and the defense federal acquisition regulations in it, even if he takes away the markings from the prime. So in essence, to your point, he's creating CUI for his downline, his subcontractor to help support it. So to answer the question fully, the National Archives are the ones who handle all the information around controlled unclassified information markings. And then there's information in the rulemaking around the federal acquisitions that speaks to that around marking it. However, you know as well as I do, the speed to do business sometimes, we as business owners, we as even individual consumers have this habit of, if we see an end user license agreement, the EULA, we just click it and we move through. And so, this I liken to, as a cyber team that works in an accounting office, where my accounting friends would say, when you start your business, get an accountant to help you put you on good footing. When it comes to doing your LLC, get a good attorney to help you put on good footing. You need a good partner with helping you who ingests all that information from all these different places, like you were talking about, and like I brought up with in regards to the National Archives or the Office of Information and Regulatory Affairs, the CMMC-AB. That's a lot of information to know. And a lot of our manufacturers are folks who do business with the defense industrial base. They're focused on what's their driver. I make this widget. And so I don't have, for lack of a better word, I don't have time to sit up here and read all these other acquisition regulations. And so it's not just the small manufacturers in the DIB, it's everybody. We all have, as a culture, we don't take those things as seriously sometimes until somebody puts it straight in our face. So to answer your question, yes, I think the unification of that will help bring some better clarity, and require your primes and the government to provide a little bit more direction and in essence add some more two-way communication that will improve that and take some of the guesswork out. But until that point, you have guys like you and I that we spend beyond the other tasks that we do for work every day. We spend our days trolling, looking for information around what's going on in this space so that we can be subject matter experts to answer those questions.
And so last question on this topic, a couple nights ago, we had the April town hall from the CMMC-AB, and there was a timeline presented of, potential rulemaking for CMMC. Just wanted to hear your thoughts on the FAR CUI clause. Any idea? I know the last I checked, it had been sent over to OIRA in February, but any idea when that final rule would be issued?
So, it's under review right now, and forgive me for not having the specific notes. I was hoping that I had my screenshot pulled up for it so I could write this note down because I thought you were going to ask this, but I know that it's going under, it's in its next phase or step right now for May or March, or not May or March, but for May and June to be reviewed in its next steps. And then the thought process is that there would be some interim rule or decision made by May of 2023. And with hopeful finalization in that late summer, early fall.
Okay. Very good. Well, Ty, I appreciate your time on answering this question regarding that CUI FAR clause. I think it's something that's been in the works for a number of years, right? At least since 2016. When did the CUI FAR clause start the rulemaking process? Do you know? So
the rulemaking, Obama's administration with an executive order started
that kicked it off. Okay.
That kicked it off, and I want to say that was 2010. In 2016.
You're talking about the 13556 executive order?
Yeah.
I think that was 2010.
So that was 2000. Yeah, forgive me, 2010. But, the interim rules and stuff like that that really began the wheels moving started in, 2018 and then 2019 with the interim rules being put in place.
Well, once it comes out, we'll have to reconvene and then take a look at what's included and how that impacts, like you said, the levels of CMMC and the type of information that's being protected within DoD. All right.
Yeah,
Thank you, Todd.
yeah, you're welcome. Thank you.